All right, good afternoon. Welcome to House Judiciary Committee's voting session on Friday the 24th at a little before noon. So we're going to go ahead. House Bill 732 is being withdrawn by the Chair of Health and Government Operations. I'm sorry. Oh, and that one too. Yeah, we'll do that one too. Could I have a motion on the withdrawal of 732? There's a motion for an unfavorable and a second for the withdrawal. All in favor of the unfavorable withdrawal of the bill, raise your hands. That's fine. We'll do it that way. Anybody opposed to the unfavorable withdrawal? All right, the bill is moved unfavorable and withdrawn. House Bill 667, Delegate Grossman's bill that we heard yesterday. She has put in a letter withdrawing the legislation. There's a motion for an unfavorable on withdrawal and a second. Okay. And another second. Many seconds. All right. And unfavorable. All those in favor of the unfavorable withdrawn, please raise your hands. 667. It's not on. Okay. I'll take a pause. 667 was heard yesterday. She just dropped off a letter today. So we're letting her withdraw the bill. That's what we're doing. So let's try that again. All right. All those in favor of the unfavorable withdrawn, raise your hands. Sandy, you only get one. All right. That appears to be unanimous to the chair. All right. So we will move on. House Bill 3 came out of the Public Safety Subcommittee and came out without amendments, correct? No amendments. Okay, there's a motion for a favorable. Is there a second? All right, we'll have discussion on the bill. Okay. So, all right. Any further? There's a question. Delegate Conaway.
What on page 3? Why is this information, page 3, line 20 through 22, the individual's age, jurisdiction, and other information? What is the other information? What could that be? What would be the other information on line 22? And why is it? Go ahead.
Delegate Williams.
The information that the center thinks would be important for them to capture about any of the firearms that are surrendered. So that,
As in race?
if the center thinks that would be important for them in order to move forward with this, but that's for the center to determine.
Okay, thank you.
Mm-hmm.
Further questions? Further comments? Delegate Valentine.
Thank you, Mr. Chair. I actually had the exact same question, but I have a note in my file that it's in the statute in the section above, so that I didn't have that question. I just want to point that out.
Okay. All right. Any further comments? We have a motion and a second. Going to a roll call. The Vice Chair? Yes. Delegate Munoz? Yes. Crutchfield? Yes. Cardin? Yes. Bartlett? Yes. Embry? Pasteur? Tolles? Schmidt? Yes. Boucher? Yes. Phillips? Yes. Tomlinson? Is excused. Erican? Taylor? Simpson? Grammer? Young? Valentine? Conaway? Kaufman? Yes. Williams? Yes. Okay. 2 excused. Now I have to do math. All right. I think that was 20. 1, 2. Yeah, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 19. 1 with 2 excused. Okay. House Bill 4.
Favorable.
It's a motion for a favorable. And a second. We're on a discussion on the bill. Anyone want to speak on the bill?
Good.
Delegate Kaufman.
I just want to commend Delegate Crutchfield. As a freshman legislator, I can't believe this is still on the books. And when I tell all of my contemporaries, they're stunned. So let's hope our Senate colleagues do the right thing. And I commend my dear Montgomery County colleague for introducing this legislation to get rid of this archaic provision.
Any further discussion? Delegate Conaway.
Can I get just a little refresher on what this bill is going to do?
Delegate Crutchfield.
Yeah, what this bill does is it eliminates, or I guess a better way to put it is it allows for the prosecution of spouses for criminal sexual assaults, rapes, etc. against their spouse.
Michael. In other words, if a person is married and the spouse says no, and the first party continues, then they could be guilty of this sex crime.
No, that's not correct.
No? How would that work?
Well, it depends on what we're referring to exactly and what touching or whatever, I mean, I don't,
Okay, we're talking
draw that
about,
out a little bit for me. What is your question?
We're talking about the rape charge.
Mm-hmm.
So actually, if the one spouse rapes the other spouse because the other spouse said no, is that rape?
Rape. So,
Yes, that's what I'm saying. I just want to be clear.
Yeah, I
so
understand.
we can tell the people what it is we're talking about.
Okay.
If your spouse, whether it's male or female, says no, you cannot have vaginal or anal or whatever intercourse with them. You can't force yourself upon
Right.
them.
It has to
If
be.
you do, then you are subject to this new bill that we're.
Yeah, what this bill really says is it says just that. It says that you, as a spouse, can now be prosecuted, all right?
Yes.
Because you have raped your spouse.
Yes.
Okay? Because that has been proven that that there was a rape that occurred. Okay? So now, yes, you can be prosecuted for that rape. So it puts it in equity with unmarried people who can do the same thing right now. Okay?
Sure. Okay. And what's the criminal penalty for that?
Good question. It depends on the particular crime or offense.
If it's vaginal rape, what is the penalty for this? What's the potential penalty?
So, Lauren, do you have that? I'm sorry.
No, I just.
Yeah, I don't.
First degree is felony, not a crime. Second is felony.
So this could be a 20-year offense against your wife
It depends on what the charge is.
for rape.
Delegate.
It's a rape charge. Your wife says you raped her,
But there has to be proof, right?
and you come to
You
court and
have
say,
to
"Yeah, I
prove
did
it.
that." Yeah, you come to court and
You
admit
have-
that you did that, and then so you could be looking at 20 years. Is that right?
You have to prove whatever the
If a
sexual
person comes to
offense
court
is.
and pleads guilty and says, "I did that,"
Well, then that's a different story. They said they're guilty, that they did something.
they
then
say I had
that's a
vaginal
different story.
intercourse against with my wife, and she said no, and I just went on with it. So now, how much potential time
Well,
am I looking
you
at?
heard the time that was mentioned.
20 years.
You heard the time that was mentioned, Delegate.
Okay, thank you.
Further discussion on the bill. Delegate Young.
Delegate, forgive me if this is a weird question. Just thinking about the interplay with spousal privilege, have we looked at it? I just don't know.
No, we did not. We did not look at that. But I do believe, who had a bill with spousal privilege? Yeah, Rammer did. Okay.
I'm just wondering, would that have any play in a criminal case?
No, it shouldn't.
Okay, thank you.
Delegate Bartlett.
So I just have a quick question, Delegate Crutchfield. Just for clarification, this bill doesn't create a rape charge,
No, it does not.
and it doesn't create any penalties.
No, it does not.
So there are no penalties within this bill. It's merely repealing the antiquated ability for a spouse to not be charged or prosecuted for raping their spouse.
That's correct.
So in that scenario that you were giving just a moment ago with Delegate Conaway, if they plead guilty, then they're pleading guilty to a rape charge. Marriage or no marriage, it's still rape.
That's correct.
Okay. One last quick question. So if you were not married and you raped someone, you are subject to the penalties of rape. If you're not married to someone, you're subject to, and you rape someone, you are subject to the penalties of rape.
Yes.
Is that correct?
That is
Okay.
correct.
And so now what we're doing is saying you're married to someone, but you raped them, so therefore you can be charged with rape.
That's correct.
Okay, I just want to make sure I
Just
got
as an unmarried person would be.
Further discussion on the bill? There's a motion and a second. Go to a roll call. The Vice Chair. Munoz. Crutchfield. Cardin. Bartlett. Embry. Pestier. Tolles. Schmidt. Simmons is excused. Boucher. Phillips. Tomlinson. Erican. Taylor. Simpson. Grammer. Young. Valentine. Conaway. Kaufman. Williams. 21. Chair votes aye. 22. Okay. Let's go to House Bill 13. Delegate Crutchfield again. This is civil remedy for hate crimes. We
Yes.
passed this last year, and it stopped in the Senate. Delegate Crutchfield, would you be willing to talk about what the bill does?
I can do that.
All right.
Yeah, what this bill does is just simply just what the title imposes on that, and that is to just provide civil remedies for hate crimes to allow for people to have a different avenue when regarding any kind of injuries, damages to property, etc. So that's all it does.
All right. There's a motion for a favorable. Is there a second? All right. Are there questions or discussion? Delegate Munoz to begin.
Thank you, Mr. Chair. I want to ask, so in discussing this bill with people, I've heard that all the crimes that I can think of, people say there already exists a civil remedy. Can you explain, is that the case, or is this going to add protection or a remedy that's not currently in the law?
Right. So yes, this is going to provide a remedy for specifically hate crime damages, injuries, etc. That is not in the law. Right now, what it does is there's a hate crimes law, and it talks about, giving, if there's any person that's targeted for their specific characteristics, race, gender, whatever, okay, it provides, of course, penalties, but they're criminal penalties, okay, including fines and jail time. But it does not talk about destruction of property or providing any kind of relief in a civil way for people to deal with that as well, because there are economic issues that come up. I mean, people, as a result of hate crimes, may lose some property, there may be some property damage, there may be some injuries, and that is not discussed in that hate crimes bill, which is a criminal bill. I'm sorry, criminal statute.
So if people were vandalized, or a church, or a synagogue, or any specific group covered under the hate crime definition, this would add a civil remedy that they could not get through other legal means, like through
Well, there's always
vandalism
tort.
or
There's always tort claims that you can make, but what we're saying here is we're going to create something specifically around the hate crimes issues, okay, which are very unique in themselves, all right? So that's what this does. But it is through a civil remedy, which is the standard for civil remedies, which is a preponderance of evidence used. Okay.
Okay. Thank you.
You're welcome.
Thank you, Mr. Chair. So I just want to make sure right now, currently, let's say a church was vandalized, they already have a civil remedy to take that person to court who vandalized them. It doesn't matter what the speech was or what the thoughts behind the crime was. They already have an ability to sue somebody for the damages that their property got. So that financial piece exists currently. There's a remedy for that right now. This would just add in a separate avenue for somebody who experienced a hate crime to go through. They could file this separate charge, this separate, I guess it's not a charge, but they could file this separate grievance with this separate thing, the hate crime thing. But now, before, they would have to do property destruction, damage, that kind of stuff, loss of, they had to close down for several days. They could get, try to get money back for the amount of time they lost, things like that. So there is currently a financial avenue that just doesn't have the hate crime label. So this is a separate avenue.
Okay, so yeah, as I mentioned earlier, there's other tort claims that you can make. You can make a claim of vandalism. You can make all those kinds of claims. But separately for hate crimes, nothing exists.
Right, okay. Yeah.
Nothing exists to give people real relief on what happens to them. I mean, there's a lot of examples of when this has been used, and that, it's something that has to be created to provide, especially now, there's a lot going on, and some of the torts don't really provide a real way for people to be made whole. And this is one way that they could possibly be made whole regarding hate crime violations.
Okay, thank you. So, Mr. Chair, I would just say we still have a hate crime criminal policy, so I'm obviously in support of that. I voted for it numerous times. But I am uncomfortable with lowering the standard to preponderance, because it is obviously a situation where somebody probably did not meet the beyond reasonable doubt standard. In the criminal case, it failed, and someone is seeking damages specifically with the hate crime label, and a lower standard for something that is absolutely so destructive for someone's life. I mean, can you imagine jobs could be hinging on this, and it's a lower standard of evidence. So I'm still going to be red on this bill.
And Mr. Chair, I'm sorry. Yeah, if I could just comment on that. I mean, we're talking about two different, particular pieces of the law. Okay, we're talking about criminal has one standard, beyond a reasonable doubt. Okay? Now what we're doing is we're saying to people that have had violations as a result of somebody targeting them for specific characteristics, race, color, age, whatever they may be. And now we're saying, because your house was set on fire, okay, because we can show that your house was set on fire, you should get some relief for that. And that's what this does. So it's not about lowering any standard. It's about creating a different avenue, which is a civil standard that's already in place for civil actions. So we're not creating something that's out of place. This is a civil claim versus a criminal claim.
Thank you, Mr. Chair. Delegate, I wonder, could this bill also apply to a group of people? And what I mean by that is not just a group of us, but if we had an organization, could this apply to that, or could it be expanded to apply to that type
No, it would apply to a group of individuals.
So I could sue, say it was,
Whatever your ties are with a group, yes. Yes, okay. It could be tied to that.
Understood. Thank you.
Vice Chair.
Thank you, Mr. Chair, and thank you, Delegate Crutchfield, for bringing this bill. I think we had this in the past and voted it. Am I correct? Yes. Okay. So just in reading the bill, I think folks are focused on the standard, but I want to point out a couple things that this conversation is missing. A key aspect to what this bill does is it provides the opportunity for injunctive relief, to tell the person to stop, essentially. It says here the court may issue an injunction to prevent or restrain an act that would constitute a violation of this subtitle. Further, later in the bill, it has the possibility of attorney's fees. And if you can imagine the value of that. If someone's going and doing something that's actually of very little economic damage, maybe they're chalking swastikas or slurs on your property, and there's very little actual cost to the damage there, you could use this statute to bring them to court, get them to stop, get injunctive relief, and you're not going to be out of pocket on the attorney's fees, because no one's paying for that for you in civil court if the police or whoever decides they're not going to do that. The other thing I would point out, again, for these kinds of scenarios where you're terrifying someone, but the economic damages might not be so obvious, but the psychological damage is there, that's an element in this bill also to the damages. So again, you can agree or disagree with whether you like those things, but I think those are important elements that are here that certainly give me reason to support the bill.
Thank you, Vice Chair. That helps explain a little bit of my question. I guess my question, I see where it says a person, and then we're talking about personal property is part of my question. And what about in the act of, say, rioting? Would a business have an opportunity there to? No.
So you're talking about something a little bit beyond that, because it really doesn't cover. So that's kind of like First Amendment kind of issues that we're now getting into. So it doesn't really cover that. But I mean, as mentioned before, if it's a group of people, okay, doing a targeted act towards somebody, then yes, that would be covered.
Okay, thank you. Yeah, I'm not struggling to understand it, so
okay.
I appreciate elaborating. So, thank you.
Further questions, comments? We have a motion already? Can I have a motion on the bill? There's a motion for a favorable and a second. All right. Any further? The Vice Chair. Yes. Delegate Munoz. Delegate Crutchfield. Yes. Cardin. Yes. Bartlett. Embry. Pasteur. Tolles. Schmidt. Boucher. Yes. Phillips. Yes. Tomlinson. Erican. Taylor. Simpson. Grammer. Young. Valentine. Conaway. Kaufman. Yes. Williams.
Yes.
Right. $17. All right. 17-4. House Bill 14 changes the grounds for divorce. I don't believe it went through. Did it go through the subcommittee? I don't think it did, but it has in the past. Okay. All right. We'll take a motion for a favorable. Is there a second? All right. Now, is there discussion or are there questions about the bill? Delegate Conaway.
Chairman, I was wondering on page 3, line 20, where it talks about a party lacks the legal capacity to make decisions. Does this mean that you could apply for divorce if your spouse had Alzheimer's or something like that?
Mr. Chair, if Delegate Conaway could repeat his question. Sorry.
On page 3, line 20, the party permanently lacks the legal capacity to make decisions. Would something like Alzheimer's, if the spouse had Alzheimer's, would that apply here?
I think if it was determined that
Yeah, in other words, they get diagnosed, yeah. They say, well, they have Alzheimer's.
Right, I don't, there's different stages of Alzheimer's, so I don't know.
Okay, I'm not an Alzheimer's expert.
I'm not either, but I'm just saying.
All right, but now I can get to what I want to get to. So on page 3, line 16 and 17, number 2, irreconcilable differences based on the reasons stated by the complainant for the permanent termination of the marriage. So if the one spouse says no, can the spouse that no was said to say that this is page 1, line 20, cruelty of treatment, and therefore I want to apply for immediate divorce. Yes, on page 1, line 20, number 1, it says cruelty of treatment of the complaining party. So I want to complain that my spouse said no, and therefore we have irreconcilable differences as outlined on page 3, line 16, and I want to apply for immediate divorce.
Well, first of all, this bill eliminates cruelty of treatment, okay? It eliminates the reasons for limited divorce, okay?
Where does it say it eliminates that? Okay.
Okay, it eliminates all that, and cruelty of treatment is one of those that you can get a limited divorce in the state of Maryland. So what it does is, and maybe I should just do this, is just explain what the bill absolutely does, okay?
No, I would just like my question answered.
Okay.
So under irreconcilable differences, if one spouse says no and other spouse says I want it to be yes, and therefore we have irreconcilable differences, can I apply for a divorce? Or can that party apply for a divorce? No longer is our body as one. Let's say a person is a strong Christian and they believe that the body is one, and now if they're being led into a certain type of temptation, they need to be away from you and want to be divorced. Can they apply for a divorce? They're saying this is an irreconcilable difference.
If you can prove it. If
you can prove
it's irreconcilable difference.
If they're a Christian, they go to the Bible. So.
You're still allowed to get a divorce if you consent, okay, as well. So if there are times when the parties can't agree, then yes.
Thank
you.
You
can certainly apply for divorce.
I'll be voting for this bill.
There are further questions or comments? Seeing none, there was a motion and a second. Vice Chair. And what I understand is we're gonna, we in the past have not turned on microphones as we go around the room. So I'm just gonna repeat people's votes so that way you can hear what, yeah, all right. The Vice Chair votes yes. Delegate Munoz? Yes. Delegate Crutchfield? Yes. Delegate Cardin? Yes. Delegate Bartlett? Yes. Embry? Yes. Pasteur? Yes. Tolles? Yes. Schmidt? Yes. Boucher? Yes. Phillips? Yes. Tomlinson? Yes. Erican? Yes. Taylor? Yes. Simpson? Yes. Grammer? Stepped out. Young? Yes. Valentine? Yes. Conaway? Yes. Kaufman? Yes. Williams? Yes. Grammer is absent. Simmons excused. Should be 20. 20. All right. House Bill 127, Vice Chair's bill. Small claims enforcement.
Used to be your bill.
Yes, it did. A while back, dinosaurs roamed the earth. All right. House Bill 127, is there a motion?
Move favorable.
Is there a second? All right, there's a motion and a second. We'll have discussion on the bill. Anyone wish to make comments or have discussion or ask questions about the bill? All right, seeing none. The Vice Chair? Yes. Munoz? No. Crutchfield? Yes. Cardin? Yes. Bartlett? Yes. Embry? Yes. Pasteur? Yes. Tolles? Yes. Schmidt? Yes. Boucher? No. Phillips? Yes. Tomlinson? No. Erican? Yes. Taylor? Yes. Simpson? Yes. Grammer? No. Young? Yes. Valentine? No. Conaway? Yes. Kaufman? Yes. Williams? Yes. believe that's 16 to 5. Yes, 16 to 5. All right. Moving now to House Bill 129. There's a motion for a favorable. Is there a second? And a second. All right, so this went to the Civil Subcommittee. Delegate Cardin. It doesn't appear there are any amendments to the legislation. Is that correct?
No amendments. It's in the posture that passed out last year.
All right. Feel like we've been here before, which I think we have, but maybe with some different people. Any further discussion on the bill? Seeing none. The Vice Chair? Yes. Delegate Munoz? No. Crutchfield? Yes. Cardin? Yes. Bartlett? Yes. Embry? Yes. Pasteur? Yes. Tolles? I'm sorry? Yes. Schmidt? No. Simmons excused. Boucher? No. Phillips? Yes. Tomlinson? No. Erican? No. Taylor? Yes. Simpson? Yes. Grammer? No. Young? Yes. Valentine? No. Conaway? Yes. Kaufman? Yes. Williams? Yes. 15-6 with one excused. Okay. The Vice Chair's bill on House Bill 131. Could I have a motion? There's a motion for a favorable and a second. All right. We're on the bill. There are no amendments that have been offered to the bill. We'll take discussion. Seeing no discussion. All right. The Vice Chair? Yes. Delegate Munoz? No. Delegate Crutchfield? Yes. Cardin? Yes. Bartlett? Yes. Embry? Yes. Pasteur? Yes. Tolles? Yes. Schmidt? No. Simmons is excused. Boucher? Yes. Phillips? Yes. Tomlinson? No. Erican? Yes. Taylor? Yes. Simpson? Yes. Grammer? Yes. Young? Yes. Valentine? No. Conaway? Yes. Kaufman? Yes. Williams? Yes. The chair votes aye. That's 19 to 4, 18 to 4 with one excused. I think that's right. Yes?
House Bill 127, from yes to no, please.
It will not change the outcome, so I'll let you change it.
Thank you.
Wait a minute. On 129, you said?
127.
127. Sorry. 127. 127 from yes to no, making that 15 to 6. Okay. Let's put that in a folder that you can read. All right. I think this is 137. Okay, is there a motion on House Bill 137? It's a motion for a favorable. Is there a second? I'm just saying. All right. Is there discussion on the bill?
Bereavement, well, when this was heard, can the good delegate from Essex describe what the bill does again,
Are
please?
you from Essex or from Essex? That's right.
Thank you. Everybody they've gotten it wrong for 9 years, so thank you.
Sorry for the delay, Mr. Chair.
You're fine. You're fine. Delegate Grammer.
So what this bill does, currently, if there's a situation where a teacher is sued the local board must provide defense for that teacher. This bill is a little bit different. What this bill does is, in a very limited fashion, provides immunity for teachers who step in to break up physical or violent altercations, if a student's getting assaulted, bullied. What tends to happen, and we hear this from a lot of teachers, and we heard this from some of the teachers who spoke in support of the bill, they said, you know, they could, even if they're stepping in to defend, frankly, an innocent student who's getting really, you know, suffering heavy bodily harm, the teacher can be sued in that case. So what this bill does is it puts in very limited liability or very limited immunity for teachers who are acting in good faith to protect students in violent situations in public schools. It also applies to staff members and administration in school systems.
So do the parents of the child that was maybe harmed or whatever still have the legal remedy of suing the school board or the LEA, or are they just totally out of luck if they want to sue somebody?
It depends on the situation, but in this case, as long as the teacher was acting in good faith, they would not be able to sue. Whoever was acting in defense in that case.
Okay, thank you.
Thank you.
We all made note of the person who made the motion. Anyway, so there's a motion for a favorable and a second. Is there further discussion? Seeing none. The vice chair? Yes. Munoz? Yes. Crutchfield? No. Cardin? Bartlett? No. Just to be clear, Bartlett has not yet voted. I was answering a question. Embry? Yes. Pasteur? Yes. Tolles? Yes. Schmidt? Yes. Simmons is excused. Boucher? Yes. Phillips? Yes. Tomlinson? Yes. Erican? Yes. Taylor? Yes. Simpson? Yes. Grammer? Yes. Young? Yes. Valentine? Yes. Conaway? Yes. Kaufman? No. Williams? Yes. 3 opposed. You want to change your vote from no to yes? All right. All right. 19-2. All right. Yep. House Bill 1. Okay. All right. So much clapping. House Bill 145. There's a motion for a favorable. There is an amendment, however, that we need to take up. So why don't we do that first? There's an amendment to the bill. We did not send this through subcommittee, but I think it, and I'll ask.
I have a wording change.
Sorry?
I have a wording change.
Okay, we'll talk to council here. Claire's going to talk about a word change and an amendment. Or maybe it's one of the
Yeah,
same.
it's a word change to the amendment. So Delegate Fraser Hidalgo, the sponsor of the bill, submitted an amendment which would just add like the Army Reserve and National Guard as armed forces units that the prospective police officer in question can be an honorably discharged veteran or current member of. And so, as you can see on the paper, it says the National Guard or the Federal Reserve components. And I'm sorry I didn't notice this before, but I was just looking at this and I was like, what is the Federal Reserve component? So I started Googling it because it reminded me of the Federal Reserve Bank. And I think that it's better worded. So there's actually 7 components, 7 reserve components of the United States Armed Forces. And so I think it's better to word it as the Army National Guard, the Air National Guard, or a reserve component of the United States Armed Forces. And I ran that by Delegate Fraser Hidalgo, and he's fine with that.
Does everyone understand the amendment to the amendment?
Yes.
Who said no? All right, let's, do you want to ask questions, Delegate Bartlett, or?
No, I didn't have a question. I just was answering your question. I didn't understand.
We would like you all to understand, so I'm just saying. But it's just seeking to clarify the language to say that if they're in the reserve, one of the 7 different branches of the reserves, which I assume is, it's including Space Force now?
No, it's the Army Reserve, the Navy Reserve, the Marine Corps Reserve, the Air Force Reserve, and the Coast Guard Reserve. Those are the regular reserves, and then the National Guard is the Army National Guard and the Air National Guard.
Okay. Yes, not the unarmed services.
Yeah, I think somebody in the bill drafting department just wrote that capitalized Federal Reserve components, and that's not a thing, really.
Okay. Yeah. Delegate Arakan had a question, then I'll go to Delegate Kaufman. Delegate Arakan.
Mine's actually on the bill, so if you want to do the amendment first.
All right, Delegate Kaufman, we're still on the amendment, Delegate Kaufman.
Okay, well, I got confused then. I was going to ask that pursuant to the rules, my name be added to the bill since it's being amended, but I guess I'm early.
We'll get to that in just a moment. Let's deal with this amendment first. So can I have a motion, is there a motion to adopt these? Well, we're going to do this amendment first. So there's a motion to adopt this amendment with the change that was just recited by council. Yeah, amendment number 1 is moved and seconded. So we're just on the amendment that deals with adding armed service, people who are in the reserves from as part of the armed services. Okay. Any discussion, any further discussion? There's a motion and a second on the amendment. Okay. All in favor of the amendment, please raise your hands. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17. All those opposed to the amendment, please raise your hands. 1, 2, 3. All right, the amendment is adopted 17 to 3. Now, if people want to be added onto the bill, please raise your hands. I'm getting there. I'm just doing it my way. Adding Phillips, Young, Conaway, the vice chair, all right, and Kaufman. All right, and Pasteur. All right, and I'll provide that to council here in a moment. Now, we are on the bill as amended, and we'll take, there's a motion for a favorable. Is there a second? All right, there's a motion and a second. Delegate Arakan to begin.
Thank you, Mr. Chair. So I know that we had passed this bill before, and I'm pretty sure it passed both sides and was enacted. Is that correct?
I don't think they did.
Because it definitely looks different to me from before. Before, I think there was a requirement that the person be on a pathway to citizenship and that they be, it seems like that part's being removed now from it. Because I remember I voted for the bill in the past, but now I'm seeing they're taking out some of the pieces that I thought were important, where...
If they're on that pathway...
So we did, this didn't exist before, so I think we must have passed this a couple years ago.
Right.
Now we're coming back in for this change to it, which is to remove that the person has actually applied to become a citizen.
Correct.
Yeah, so I think unfortunately, I'm uncomfortable with the change we're making because I really liked the bill as it passed originally, so I'm going to be a no this time.
All right. Delegate Grammer, then Delegate Munoz.
Yeah, so I believe we passed this either last year or the year before, and the explanation of the change and why I supported it was because it was to provide a path for people who had been honorably discharged as long as they were pursuing citizenship. Because it takes a long time, as long as you're in that pipe, so it could take months or years, these folks could participate in law enforcement. So the question I have is, why are we at this point saying if you're a person who doesn't actually wish to achieve citizenship, we're actually going to have non-citizens enforcing our laws? And I don't remember anywhere in the testimony at any time that someone provided that justification. So can someone answer that for me?
The Vice Chair.
So part of, I don't think people were denying it might be a good idea to have these particular officers seeking citizenship. But if you look further in the bill at the language that's being struck, it does talk about the old requirement said, provided the individuals applied to obtain citizenship and the application is still pending approval. And then right after that it says, the certification of that officer shall be terminated if they fail to obtain citizenship as required. And so part of the problem that was flagged by this clause was, as you know, the uncertainty for the hiring department about whether this is an officer who could last, whether it was worth investing in that officer because it's unclear whether you'd be able to keep them. And even if they had gone through the process, I mean, just the language of it here puts a cloud, I think, over the whole employment, that if we just sort of assume that someone's a honorably discharged service member who is now otherwise, no criminal history, none of that, otherwise qualified to be a police officer, but for this one thing, again, I don't think nothing's stopping them from seeking citizenship. And I think that's certainly the expectation, and it certainly was what was put in prior law. But that other issue about, well, you're sort of creating a bad HR scenario, the way the law is set up. If you just assume in good faith that these people are going to be doing this, I think that's a little bit better. So I think that's the reason for it. I understand where the question comes from, but I don't think people were trying to just say, oh, let's just skip this part altogether.
Right. So the idea is that they probably are going to pursue their citizenship, but my problem, I think, is just you remove the backstop altogether, and it's like okay, but I appreciate the answer.
Delegate Munoz, then Erican.
Thank you,
Delegate Munoz.
Thank you, Mr. Chair. So that's kind of my concern as well. And when I look at the Maryland State Police written testimony, they're saying that this legislation repeals the requirement for an applicant who's a permanent legal resident of the United States and is honorably discharged veteran of the United States Armed Forces to apply for U.S. citizenship prior to their certification. So I guess going along with that, there's all these issues that they deal with in terms of background checks, being allowed to be involved in federal work, having access to federal documentation that is of a classified nature. And they were even talking about like the presidential inauguration. They use troopers for that type of stuff. And so any troopers who are hired with this exception would be prohibited from working in all these capacities. And so I guess this is why the Maryland State Police were opposed to this. And so I'm just wondering if the Maryland State Police are opposed to this, why are we putting this bill forward?
We have a lot of law enforcement agencies in the state with many different, views on that matter. Dealing with, the scenario, the city of Tacoma Park has its own police department. I don't know how often they're doing, security detail kind of or, you know, things that implicate national security. We just had another bill in here talking about older law enforcement officers and how they don't actually do a whole range of activities, and maybe we're on desk duty, right? And so, again, I think there's just a range law enforcement types. We've heard, I mean, basically every time someone brings in a police bill, we talk about the challenges every department in the state is having right now, recruiting and bringing more officers on board. So again, I understand the questions about the deletion of that provision, but again, if you put it back into context, how we got to that point, the goal was not to have officers who are not seeking citizenship, right? I mean, the legislative history of this, what's being proposed here, I think is quite clear that that's not the goal. But again, putting that level of detail into law creates its own complications that sort of thwart the overall goal of getting trustworthy people who have served the country, are here lawfully, and are allowed to be here, but for this one thing are currently facing issues with this one job category. I mean, it's a policy call. To be sure, this is a policy call, but again, the recruitment issues, everything that we've heard, I think this is the right move.
And I think sometimes the part that gets missed, and the part I think we emphasize in the amendment, is that they have to have already served in the military. They took an oath to defend the Constitution of the United States when they got sworn into the military. They honorably served in that capacity, and now they wish to be a police officer. And the thing that could be holding them up is that they are only a permanent legal resident. And I go even further to say people who serve in the reserves, again, are swearing an oath to the Constitution of the United States, and are in that position of trust. And so, you know, they have taken the steps to become a permanent legal resident, which is not an insignificant thing in and of itself. And so that's why I, at least as I see it, that it's not somebody who just entered the country illegally and then decided that they were going to become a police officer. Delegate Young.
Few things real quick. Thank you, Mr. Chair. First, looks like the bill was passed in 2019. And then secondly, I was going to highlight that in testimony, I see that 3 states have no citizenship requirement: Colorado, Vermont, and our neighbors in West Virginia. 7 states only require permanent resident status or work authorization: Hawaii, Louisiana, Minnesota, North Dakota, Oklahoma, Utah, and Washington. And then lastly, Mr. Chair, just want to highlight the attrition numbers in Baltimore City. We are bleeding officers. We really need them, and I love to see these barriers taken away. 97 short in 18, 248 short in 19, 217 in 20, in 21, 201 in 22, 314. So just hoping that this could help make a pipeline for some of our officers in Baltimore City, Mr. Chair.
Is there further discussion on the bill? No?
Answered my question.
All right. Thank you. I had a motion and a second, I believe. No, we did the amendment. I'll take a motion. Motion and a second heard. Okay, for a favor. Now, we'll go with the roll call. The Vice Chair. Yes. Delegate Munoz. Yes. Crutchfield. Yes. Cardin. Yes. Bartlett. Yes. Embry. Yes. Pasteur. Yes. Tolles. Yes. Schmidt. Yes. Boucher. Yes. Phillips. Yes. Tomlinson. Yes. Erican. No. Taylor. Yes. Simpson. Yes. Grammer. No. Young. Yes. Valentine. No. Conaway. Yes. Kaufman. Yes. Williams. Yes. Passed. With 18. 18 to 3. All right. Now we have Cold weather system moving across. And we have Vice Chair's bill, House Bill 173. There's a motion for a favorable. There are no amendments. I imagine there might be discussion. I think I heard did I hear a second on the favorable? Motion and a second on the favorable. Discussion on the bill, House Bill 173. Seeing, yes, we did. Yes, yes, we did. Roll call. I don't see anybody else. The Vice Chair. Vice Chair votes yes. Munoz? No. Crutchfield? Yes. Cardin? Yes. Bartlett? Yes. Embry? Yes. Pasteur? Yes. Tolles? Yes. Schmidt? No. Boucher? Yes. Phillips? Yes. Tomlinson? No. Erican? No. Taylor? Yes. Simpson? Yes. Grammer? No. Young? Yes. Valentine? No. Conaway? Yes. Kaufman? Yes. Williams? Yes. 6 noes, 15 yeses, and 1 excuse. Motion is adopted. Goes to the floor. Now, 2 more. House Bill 232. Did this go to subcommittee? It did. What did the subcommittee do, Madam Subcommittee Chair? Unanimously, even. There's a motion for a favorable. There are no amendments in the file. Is there a second? All right. Discussion on the bill. Delegate Munoz?
I was not here for the hearing. I was sick, and I'm struggling with this bill. Could you kind of explain it a little bit to me?
You want to, or you want me to let her? Delegate Williams.
Sure. So basically, what this bill says is that with regards to child in need of assistance cases, the presence or use of cannabis alone cannot be the sole determinant in determining neglect in those cases.
So, were there any like medical groups or like pediatric groups that like weighed in on this?
I'm not certain. I don't think this year there were. This is not the first year we've had this bill. But there wasn't any opposition from, well, nearly anyone on this bill. Vince McElroy, but that's about it.
Okay, so is that just like people are using it
so with it
ever, or like in the presence of the child or while caring for the child?
Let me go back to the text of the bill, so I want to make sure I'm quoting this right. So neglect basically cannot be defined to include the use of cannabis by any parent or individual who has the permanent or temporary care, custody, or responsibility for the supervision of the child. It doesn't specify whether the use is done in front of the child or not in front of the child. It's just saying that that use solely by itself cannot be the sole determination of neglect in child in need of assistance cases. Obviously, if there's other factors going on, then yes, those factors can certainly come into play in coming to a finding of neglect in those particular situations.
Okay, so if we were substituting cannabis for alcohol, then as the law is now, it would be a parent using alcohol, you know, going out for you know, date night would then qualify for neglect. Is that correct?
Alcohol by itself is not even alcohol.
No, I'm saying if we substituted cannabis in this bill for alcohol, and we said, oh, a parent, you know, uses alcohol recreationally on date night.
Right. That by itself could not be a determination of saying that the parent has been neglecting their child.
Okay. But if it was cannabis and we don't pass this, it can be.
It can be, yes. And it is currently actually a factor.
Thank you.
Yes.
Delegate Schmidt and Erican.
Thank you, Chair. Delegate Williams, you explained a little bit about the alcohol. Are there other solely examples that we can relate it to? Cocaine or
Yeah, I
PCP
think
or
just any illegal drug, any type of drug that's considered illegal, a class 1 narcotic, typically that's factored into these types of cases. And since we're going down this road as a state and legalizing the recreational use of marijuana, the policy thought process behind this was that then we should treat cannabis the same way we treat alcohol, the same way we treat tobacco.
Okay, thank you. I'm struggling, like, lines 1 through 12 really talk about the child with abuse and neglect and development disability. I mean, is there a reason why it's kind of listed that way? I mean, is that to...
I think that's existing law. Are you on page 2?
Yes.
I'm starting at line 9.
Yeah,
Yeah.
Well, yeah, in that area, yep.
Yeah, so lines 9 through 12 is existing law.
Okay.
So there aren't any changes to that. So if the child's health or welfare is being harmed or is placed at a substantial risk of harm, that's still a factor
Okay.
that they can consider.
So an example would be the neighbor calls and says, this child's being neglected because the mother, father is using cannabis. They wouldn't be able to be solely...
Right. They would have to show something else, like they haven't been feeding the child or something else along those lines.
Okay. All right. Yep. Thank you for explaining.
Delegate Erican, then the Vice Chair.
Thank you, Mr. Chair. So, yeah, just for people who are sort of on the fence here, this bill is so desperately needed. There has been multiple women that I know of personally, have talked to, who have had their children removed in the hospital because they have tested positive for cannabinoids, and in the end, after their child was removed for multiple weeks, it turned out they had used CBD oil. They weren't even using cannabis. So, so this is going to immediately alleviate that that issue that we're facing. That has happened to numerous women in the state of Maryland. So, and those women that didn't have a medical card, they were just not using actual cannabis. So, I'll be a really strong green on this one because we've got to stop taking people's babies.
Vice Chair apparently doesn't want to talk anymore. All right. Any further discussion on the bill? All right. I think we had a motion for favorable in a second. Go to the Vice Chair. Yes. Munoz? Yes. Crutchfield? Yes. Cardin? Yes. Bartlett? Yes. Embry? Yes. Pasteur? Yes. Tolles? Yes. Schmidt? Yes. Boucher? Yes. Phillips? Yes. Tomlinson? Yes. Erican? Yes. Taylor? Yes. Simpson? Yes. Grammer? Yes. Young? Yes. Valentine? Yes. Conaway? Yes. Kaufman? Yes. Williams? Yes. All right. 21. Okie dokie. Last bill, asked for by the Treasurer of the State of Maryland, House Bill 394. There's a motion for a favorable. Is there a second? And a second. Is there any discussion? Delegate Erican.
Thanks. So I just want to make sure that I understand the process. So let's say somebody doesn't get the email or whatever. Is there some kind of, will they suffer in some way if they don't get the email? Like, will it negate their ability to appeal or something like that? Could it have any negative repercussions for the person if they just don't seem to receive the notice?
The bill allows for email, but it also says that the notice can be mailed by regular mail if regular mail is the only available means of notifying the claimant. So if they don't have an email address, they'd have to use regular
mail. Okay, so it's whatever they put on the form that they choose to be contacted by.
Right.
Okay, that sounds good.
Delegate Cardin, then Schmidt.
Thank you. The other thing that they testified to when we asked that exact question was that this is like a fail-safe. Like they have like 4 or 5 different times. They don't lose any rights because they're required to do all kinds of other things before they can take away whatever property they're trying to deliver or whatever information. So he made us sure that this is just an additional tool, not taking away rights.
Delegate Cardin explained it eloquently. I'm good.
Is there a reason that we take out the certified mail piece?
I feel like it was the cost that was the bigger piece of it. Yeah, I believe that's what I remember from the hearing, was that there was a question about the cost, and that people have these other ways to receive the same information.
All right, thank you.
All right.
80,000 cent, and it was $2.32 or something. He gave a number associated with this cost savings or something like that. So yeah, so he broke it down.
Anyone else? We have a motion and a second. The Vice Chair? Yes. Munoz? Yes. Crutchfield? Yes. Cardin? Yes. Bartlett? Yes. Embry? Yes. Pasteur? Yes. Tolles? Yes. Schmidt? Yes. Boucher? Yes. Phillips? Yes. Tomlinson? No. Erican? Yes. Taylor? Yes. Simpson? Yes. Grammer? Yes. Young? Yes. Valentine? Yes. Conaway? Yes. Kaufman? Yes. Williams? Yes. All right, favorable motion passes. Okay, thank you all very much. We'll have bill hearings next on Tuesday. Next week, be aware of subcommittee announcements. Do we have any subcommittee announcements for some people? Public safety?
And via Zoom, one bill.
All right.
We're going to meet on Wednesday, civil, and we have at least one bill that we have to get out and maybe more.
All right. Family and juvenile Wednesday at 11:30. All right. And
Gonna be voting again Thursday at 11.
criminal voting again Thursday at 11. Thank you all very much.